We're going to hopefully have a very informative and very full presentation today. We're going to touch on a topic that's not getting a lot of press these days, and that's the mass termination of employees. But thankfully, by attending this seminar today, at least we'll have accomplished one of our minimum 5 daily tasks for the week. This is the intersection of bankruptcy and labor and employment law. It's part of the Financial Poise Bankruptcy Intersection series. You can read more about Financial Poise on slides 3 and 64 of this slide deck. Our panelists today, a great group: Robert Richards of Denton's LLP, James Sullivan of Seyfarth Shaw, Heather Van Meter of Miller Natch, and I'm Anthony Calley of Stinson LLP. You can see our names on slide 8, and you can read our bios on slide 56 through 59. And we're not going to bore you by reading our bios out loud. If you'd like more information on us, just check out our bios and our web pages. With respect to the slides, I'll try to call your attention to whatever slides we're talking about that are relevant to the discussion. I'll try to remember to flip them timely. But if you're listening and not watching the seminar, it's fine. The slides are not essential. They do not have a ton of listed dialogue on there. So just follow along as you can. Thank you to our co-producers, who are the National Law Review. You can read more about the National Law Review on slide 4. And Financial Poise webinars are also supported in part by our sponsors. And the sponsor for this webinar is Max Asset. More info on slide 3, I think also slide 6. And the last thing before we begin, slide 5 contains a disclaimer. You are not our clients. We're not your lawyers. What we do here today is for your general education and not for you to act on without appropriate legal advice. So without any further ado, here we go. For those following along on the slide 13 provides a general outline of what we intend to discuss. And somewhat optimistically, we've listed 7 subtopics to discuss. We'll try to cover as much ground as possible. Can't promise that we'll get to all 7, but in case you need for reference, the material will be there. And we'll begin from an employee's perspective, discussing these bankruptcy intersections. So Robert, why don't you start us off? I'm an employee of a company that has just filed bankruptcy under Chapter 11 and seeking to reorganize. I'm owed $20,000 in past due wages from prior to the bankruptcy filing. How can I get paid for those wages?
Well, hopefully my employer is proactive and will tell us that I'm going to get paid and that they filed and why, and that hopefully they're not disappearing on me. But as an employee, I have limited leverage. It's really my employer that, should be looking out for me, because otherwise I can easily go and get a job somewhere else for most employees across the street, and I'd be difficult to replace. There is a set of priorities in the Bankruptcy Code, and that's the slide you put up with secured creditors and costs of the Chapter 11 coming ahead of my wage and my priority claims. That being said, and we'll discuss, line employees generally get paid pursuant to what's called a first day motion. And so hopefully it'll be easy, and my check will just hit my account. When we talk a little more from the employer perspective, often employers try to time something so that the current payroll is already at the ADP or the payroll processor, so the check, that my direct deposit just shows up in my check. For most employees, their wages for the time period leading up to the filing will be under $15,150, which is the current dollar limits, and will be for the last week or two, and I'll just get paid that. But let's talk about some exceptions. So, the case you gave, I'm owed over $20,000, not $15,150. So I may only get paid $15,150 with this paycheck. And people who, obviously highly compensated people, especially they get paid only, once or twice a month, might be above that limit. Other kinds of people who might be above that limit would be someone who gets material sales commissions that are payable quarterly or based on some sort of performance. Another situation where I see the 15,150 exceeded often is PTO claim. If you have an employer that has PTO, and especially if it continues from year to year and accrues and is not lose it or use it, that's another situation. And then another thing that's important is you see the words earned within 180 days. So if I'm an ex-employee and I got severed, I probably won't be covered by the wage program because the employer doesn't think they need me. And even if I file a claim, if I got severed over 180 days ago, I may not have a priority. I may just have a general unsecured claim that may get paid cents on the dollar. So those are all things that I would need to consider as an employee in terms of what and when I'm going to get paid.
So I think you just touched on it, but then in my scenario, if I'm owed $20,000, I have approximately $15,000 priority claim. And then what happens with the remaining $5,000 approximately?
Yeah, I'll receive at some point in the case, especially if it's a Chapter 11, a notice of bar date, and I'll need to file a claim for anything that wasn't paid to me under the first day motion. And I'm in a case right now, and several employees have filed individual claims in that case for exactly that reason.
Heather, aside from my wages, can I possibly recoup benefits that my employer owes me, such as 401k contributions?
Right. So you can, under the wage priority, there's also an employee benefit priority, and that applies to certain employee benefit plans, just the unsecured claims for those. That does include 401k and other retirement plans. Again, it's subject to the 180 days for services rendered within the 180 days before the bankruptcy petition filing, or when the business stopped operating. But it's still capped at that 15,150 minus the wage priority. So, for example, if you've got, wages of 20,000, as in our example, and then on top of that, you've got 401k contributions that are due, and possibly, sick leave bank and things like that, you may not be able to recover that, as opposed to having just a general claim that you need to make for the excess from the 15,150. Also, for employees, one thing to think about is there's several pots of employee benefits. So you may have benefits, for example, under employees' contribution to paid leave under an equivalent plan from a state that has paid family leave. Oregon and Washington have those kinds of state programs with equivalent plans being allowed. So you may have loss of contributions towards those plans because it acts somewhat like an employer and employee shared tax. So depending on what benefits you're talking about, the primary one that people worry about, I think, is the retirement plans. But there's a lot of, health savings accounts, other contributions and employee benefit plans that are affected by this cap. And so employees may not think they have a general claim that they need to assert in bankruptcy because they've gotten their base wages paid. However, when you start looking at employee benefits, they may really have a much larger claim and need to assert that claim in the bankruptcy in order to recover all of what's owed, and especially if you've got health savings accounts, retirement plans, matching operations, things like that.
Just one brief supplement. The 401k money, it relates to future contributions like an employer match. So withholding from your own paycheck generally isn't considered to be property of the estate. And let's say you have 100,000 in your 401k, that's your own money. That's not available for creditors. What we're talking about here is just a future, like a matching contribution from the employer.
Thanks for that distinction. James, switching hats, and Robert started to touch on this a little bit previously, but as a company in bankruptcy, what do I do when I'm filing and I want to take care of my employees' wage claims?
I mean, the best thing an employer can do is try to be proactive to pay all the pre-petition wages and commissions and what have you prior to the bankruptcy filing. Sometimes, I was representing one debtor where they actually were able to borrow money because they didn't have it in order to be able to do that, because they wanted to make sure that their employees were taken care of. But if they don't have the ability to do that because of lack of funds or lack of lender consent, for example, then they can file what Robert referred to as a first day motion. So typically speaking, in the beginning of a bankruptcy case, a debtor will file a number of what are called first day motions. And these are typically important motions where you're looking to get relief from the judge right away at the beginning of the case, because these are very important matters. And a debtor that's looking to reorganize in a Chapter 11 needs its employees. If it starts losing employees because they're not getting paid and they start looking for jobs, then your ability to reorganize is going to be greatly diminished. So at the beginning of the case, the debtor will file a motion looking for authority to pay any of the pre-petition wages and salary, commissions, other things that may be owed to the employees. Typically speaking, there's going to be some kind of cap on that. Oftentimes, the cap is the priority cap that Robert referred to earlier, which is currently set at $15,150. It's going to be increased by 3% at the end of this month. Sometimes you might be able to get a little bit more. It depends upon the financial situation of the debtor, the importance of the employees to the reorganization, and the likelihood that they might leave. Might be able to get even a little bit above that, but it depends. It's going to be a negotiation typically with the lender. The U.S. Trustee's office may weigh in. Now, there could be a difference in treatment. A lot of times when a company files for bankruptcy, it may have non-W-2 employees. There could be 1099 independent contractors. There could be temporary staffing agencies. So it's not even a direct relationship with the debtor. So the Bankruptcy Code treats those each of those persons differently. So the W-2 employee is entitled to a priority claim as discussed by Robert previously. Again, the $15,150 covering things like salary, wages, commissions, severance, sick, vacation, things like that. With respect to a 1099 independent contractor, typically only covers commissions for sales of goods and services, and it can cover a single member LLC, for example, or a single member S corp, if it's represents more than 75% of that person's salaries is the debtor, because in that situation they really are like an employee. The staffing agency situation, I had that in a case one time, and it's a little bit tricky because it's the staffing agency that's the creditor. It's not the employee. And so the employee has to look to the staffing agency. They'll still have to get paid by the staffing agency. And the staffing agency is not going to be able to assert a claim on behalf of its employees as sort of like indirect employees. So, these things, often get overlooked in the beginning of a case, but it's important to keep all these things in mind.
In other words, if you're counsel representing a company that's about to file a bankruptcy, you need to have a good understanding of how your client employs its employees, or how they pay the employees, how they're contracted with that company. Is that safe to say?
Yeah, I think that's safe. Oh, go ahead.
Yeah, go ahead, Heather.
I was just going to say, I think that's safe. I think one of the issues is that the Bankruptcy Code appropriately protects employees and their wages, but doesn't have the same protections necessarily for outside sales, commission earners, or 1099 independent contractors. And so if those types of workers are really crucial to your business, you really want to plan ahead. And it's, kind of the pre-planning is talked about on slide 21 too. But really plan ahead on how you're going to make sure that those workers, the outside salespeople, commission-based earners, and 1099 independent contractors are going to be treated, and if you can, include those in first day motions so that if they're crucial to your operations, that they can continue to work and get paid.
And one question
Jumping off on that.
Go ahead.
Well, Robert, I'm going to turn it over to you anyway, so feel free to add what you want. But talking about pre-planning, if I'm an officer or director of a company that's about to file a Chapter 11, what wage-related matters do I really need to consider prior to the filing?
Well, besides just wanting to retain my employees generally for the good of the business, there's certain things, and it depends on the state, where there can be personal liability. It's pretty uniform both at the federal and state level that if there's trust fund taxes, like employee withholding taxes for Social Security or for income taxes, the employee's income taxes, I'm really collecting that as an agent of the state. And if I use that for operations and don't remit that to the state, the theory is I'm kind of stealing the state's money, and therefore I should be personally liable for that. So that is important. Some states go beyond that. So some states would also take the position that the last 2 weeks of wages, if I don't pay that there could be personal liability. Some states would even say PTO, especially if it's it's subject to a cash out when my employee leaves. There might be personal liability for that. So I really want to make sure all of those things do get paid. When you use an outside payroll service like an ADP, like the trust fund taxes generally do get paid. Where I get nervous in helping a company prepare is if it does its own payroll, because you would think officers and directors would always make sure that the payroll taxes get paid. But when some entity's running on fumes, it's an easy way to have some cash that you don't otherwise have. So I see an unfortunate number of companies where they're past due a month or two or even more on remitting their withholding. And why I may be able to protect myself as an officer and director by resigning for going forward, it doesn't protect me for what's happened in the past.
Certainly a lot of debtors where hope springs eternal. They think, oh, I'm just going to skimp this payroll, but I'll get back to it next time around. It doesn't always happen that way. In fact, most of the time, it doesn't improve at all. So we talked about needing bankruptcy court approval to pay employees for pre-petition wages. Heather, once my company has filed, now going forward, wages that accrue after the filing, do I need bankruptcy court approval to pay those?
Generally, wages that are earned and to be paid after the bankruptcy court case is already filed is going to have what's called an administrative expense priority. And generally speaking, you don't have to get specific court approval to pay those. So you do have a bit more flexibility in that way. You don't have to keep going back to the court every week or 2 weeks, things like that, to pay wages. That really applies to pre-petition earned wages that you want to pay after the bankruptcy case is filed. So it does make it a little easier. But the problem with that is you still want to make sure that the wages are being paid in the ordinary course of business, and whether they're based on regular wages that are regularly paid or a contract that establishes the wages or salary to be paid, that you're following those terms precisely. If you've got if you're going to try to substantially increase somebody's wages or salary or their commissions or things like that, if anything's outside the ordinary course of business, then you're going to have to get court approval for that. So especially if you're talking about substantial increases in salaries. And that can happen if you've got a number of people who depart, right around the bankruptcy time period, but you want to make sure you're keeping employees there, and you may want to give bonuses, retention bonuses, increased in compensation or commissions, things like that, to make sure that people who are staying are going to stick with you through the bankruptcy process, then that's probably going to be outside the ordinary course of business, and you're going to need some kind of court approval for that process, usually or authorization for a non-ordinary transaction or a similar process.
Jumping off of that point, Robert, what if I have that concern? A lot of my employees are scared by this bankruptcy process. They're frightened of the uncertainty, and I have just absolutely critical employees that I need to retain in order for this business to be viable. What can I do in the bankruptcy context to keep those individuals?
Well, early on, you do messaging as we discussed and say, here's why we filed. Hopefully we're either filing to a sale where you'll have your job or a reorganization where you'll have your job. But sometimes that's not enough. And there's kind of two things that you can do. One is what's called a key employee retention program. It's essentially a stay bonus. I've kind of seen two flavors of it. One is, you just stay through X date and you get a bonus, to encourage people not to be looking and focusing on their job. Sometimes it's two tranches. So you stay through some interim date and you get a bonus. And then you stay through the end of the case or the closing of the sale, you get another stay bonus. And all you have to do usually to get that bonus is to stay. Now, from the employer's perspective, there are other potential claims. Somebody might have individual severance agreements. Someone might have WARN Act claims if I do have to shut down. So normally if I do a CURP program like that, as part of getting the CURP, I would have a release of any other claims. So I don't, as the employer, I'm not at risk of paying twice or having to litigate other severance type claims down the road. Part of the, why employers might like to have a large CURP plan. Someone's financing your case. It's either a DIP financer or it's the existing lender from their cash collateral. So it'll be a negotiation as to a program large enough to be effective, but not so expensive that the lender won't fund it. Then there's a different program, which is called a Key Executive Incentive Program. And that's truly for decision makers. So the president, the CFO, the treasurer, you might have someone with, for instance, a director title or something, but unless they really are, a decision maker at the company and not, just someone running, for instance, a local nursing home or something, they would not be considered a key executive. And there are special rules Congress adopted back in 2005 because the belief then was that the top executives were getting too much of this money and the standards to get it were too easy. So Congress imposed special restrictions just for those kind of programs where they can't get a stay bonus. They have to get something based on an incentive, and the case law guidance is that incentive quote can't be a layup. So it's not something that you're automatically going to be able to meet. So kinds of measurements I've seen in programs would include, are you meeting your bankruptcy budget or exceeding it by X percent? How's your EBITDA doing during the bankruptcy? For a sale case, it might be, does the sale close earlier than expected, or does the sale marketing lead to a certain price where creditors get more? There can be any number of incentives, but it really needs to be something that is somewhat of a stretch and not just a kind of disguised stay bonus.
What do you see are the most common traps when debtors are trying to get a CURP or a kite plan passed in bankruptcy court?
Yeah, I mean, before I file, I usually am already working on the plan. So even if it's not adopted first day and it won't be adopted first day, at least I can announce to the employees and executives, I'm going to be doing a plan and here's what it's going to provide. And, I run that by my comp committee. I run that then by the board after the comp committee signed off. Sometimes I have a compensation consultant like a Watson Wyatt involved, helping me evaluate what's market for that kind of plan. And I'm talking to whoever's financing the case, whether it's my existing secured creditor or my new DIP lender, about it and making sure that these funds are in the budget. There are some other players, though, that really only come on the scene after you file, and there's no way to negotiate in advance. One of those is the Office of the U.S. Trustee, which is basically a watchdog to look at the Bankruptcy Code is being honored. And for instance, you'll see cases where the only person objecting to a keep is the U.S. Trustee, where everyone else is kind of on board, but the U.S. Trustee says, I think this is the layout. I think this is a disguised curb. And sometimes those objections prevail. Sometimes they don't. As in all things bankruptcy, usually they get negotiated out rather than litigated to the nth degree. But there are decisions out there on that. The other one is your official committee of unsecured creditors, which will represent your trade creditors. Maybe if you have unsecured bonds, your unsecured bonds. If you have material personal injury claims, sometimes you'll see a personal injury claimant on that, or sometimes a union will be a member of that. And, they may well object, and you may have, different people with different viewpoints on the committee. I mean, you may have bondholders saying, I want as little CURP as possible. And you may have the union's members saying, I want as much CURP as possible. And they have to fight it out in the creditors committee. And the bottom line is, they can object. Ultimately, the bankruptcy court can rule, but often on these kinds of things, the bankruptcy court encourages the party to settle, maybe with some guidance, and usually you end up with a modified plan versus a flat out trial and maybe an appeal.
If you're following along on the slides, you'll notice a slide in here, it's slide 28, about special rules for employing professional persons. We don't intend to really go into this too much because it's really bankruptcy specific and not just general labor and employment law that then mashes with bankruptcy. But just know that if you're about to file bankruptcy and you need to employ debtors counsel or special counsel to litigate a claim, or a chief restructuring officer or an investment banker to sell assets, that the bankruptcy codes in sections 327, 328, 330 have special rules for employing those persons, standards that they have to meet, and the standards for being able to pay those persons. So just be aware that those are out there. And if you want, you can reference slide 28 for a brief summary of those issues. So I want to switch focus a little bit to not just paying employees and how to get that done in bankruptcy, but how to treat employment contracts in a bankruptcy context. And we'll first talk about this from the employer perspective. So James, I'll switch to you. I've got company Y. It would be company X, but I feel like that has a different connotation these days. So company Y in bankruptcy has employment contracts with several of its employees. Can it shed those contracts if they're no longer beneficial to the company?
Generally, yes. I mean, it does need court approval. So the debtor would have to file a motion to reject the executory contract. And it's not too difficult to satisfy the burden. Basically, the judge is going to look to the debtor's business judgment. So as long as it's there's not some improper purpose for rejecting the contract, or some type of bad faith, it's likely going to be granted. Parties do have an opportunity to object. My guess is that if the lender and the committee strongly objected because it was they perceived it as a valuable contract and we really needed this employee in order to reorganize, maybe it would cause the debtor to revisit it. But for the most part, the court is going to give a lot of deference to the debtor's business judgment in that circumstances. In terms of what the ramifications of that would be, typically speaking, these employment contracts often have severance provisions in it. The the damages claim that the employee is going to have is going to be capped. The 502b7 of the Bankruptcy Code limits the damages for termination of a contract to 1 year of future compensation plus whatever might have been owed prior to the termination or prior to the bankruptcy. The agreement might have a requirement that the employee provide a release in exchange for any type of severance agreement. That issue has been litigated in the bankruptcy courts, and it's typically been upheld. One issue that kind of comes up frequently, in which there is not a consensus at the moment, is what type of priority would you grant to a severance payment on account of a rejection of an employment agreement that occurred after the bankruptcy filing. So the courts oftentimes will look at this in a couple of ways based upon the type of severance that's included in the agreement. So if it's looked at as a reward for years of service, then typically speaking, the bankruptcy courts are going to treat that more of as a compensation for prior services. And so, maybe they will prorate it based upon the length of your employment that occurred prior to the bankruptcy case versus after the bankruptcy case, and sort of prorate it. If the court treats it as compensation in lieu of receiving sufficient notice of termination, kind of like in order to give the employee an opportunity to find a new job, for example, then there's a chance that they may treat it as entitled to administrative priority, which would typically have to get paid, or at least would have a higher priority in the case. So, but right now there's really no consensus on that, so it's a little bit tricky.
So if that same company wants to, instead of rejecting an employment contract, wants to accept that employment contract, wants to assume it, what does it need to do?
Then it would also have to file a motion. In order to satisfy the motion, you're going to have to cure any default. So if there were any monies owed under the contract or any other obligations that are owed under the contract, then you'd have to cure those, at least to the extent that they could be cured. And you're going to have to show adequate assurance of future performance. So you can't expect somebody to agree to stay on if they're not going to get paid, for example, right? With a employment contract, it's I think it's also tricky because we do have a thing called the 13th Amendment. You can't force somebody to stay employed. So if the employee really doesn't want to stay employed, you can't force them to stay on. But that being said, oftentimes it's something that the employee would like to see happen, because if the contract is assumed, then, like I said, any subsequent rejection of that contract is going to be entitled to administrative priority, which is the highest priority in the bankruptcy case after the secured creditors.
Heather, what if I'm selling the company as part of this bankruptcy process, and the purchaser wants all these employees, and so I want to assume that employment contract and then assign it to the purchaser of this company? Can I do that?
Yeah, the Bankruptcy Code itself allows that employment contracts, just like other executory contracts, can be assumed and then assigned to either a third party or a new company, a purchaser, or things like that. So that is possible. However, most employment contracts, or at least the ones I see and write, most of them have a non-assignment clause, or at least a clause in the contract itself requiring both parties to agree to an assignment prior to the assignment occurring. And so you'd have to look at both the Bankruptcy Code there as well as the terms of the employment contract itself. And that's true even in at-will states. When you're dealing with an employment contract, the terms of the contract are going to hold there. So you do need to look at that. And then if you're talking about assignments, depending on the outcome of the bankruptcy itself, for example, if a new employer is taking over and purchasing the stock of the debtor as part of a Chapter 11 plan, then you may be in a situation where the employment contract is essentially going to be taken over by that new entity. So there's ways to structure it, the Chapter 11 plan, depending on how employment contracts are written. This can sometimes come up in, for example, large healthcare organizations where there's a number of employment contracts with key doctors, physicians, surgeons, things like that. So you may have situations where the Chapter 11 plan is created in a way to allow the easier transfer of those employment contracts under an assumption and then an assignment. So it's possible, but you'd want to look at both the employment contract language and then also the Bankruptcy Code and the Chapter 11 terms.
Reverse the roles. Let's say I'm an employee. I filed an individual Chapter 11 or Chapter 7, and I want to reject my employment contract with my employer. Can I do that?
Right. I'll let probably Robert or James chime in here, but generally, if the purpose of the filing of the bankruptcy for the person, the individual, is to try to get out of an employment contract, that's not going to be an allowed use of the bankruptcy process. So again, it'll go back to what the Bankruptcy Code says, but just trying to file personal bankruptcy to get out of the terms of an employment contract is shall I say, disfavored.
Yeah, just a nuance on that. So I might be able to reject to not have to show up at work, but if I'm rejecting, saying I'm trying to get out of my non-compete, I'm trying to get out of my confidentiality, I'm trying to go work for the competitor across the street, that's where it gets tricky. And you generally, even if you could reject and go work someplace else, it doesn't mean you can go and violate all those other provisions or take your employer's trade secrets or the like.
Thanks for that distinction. So we've talked about employment contracts with individual employees. We're going to switch focus now and talk about collective bargaining agreements. Robert, can you start us off with what can a debtor do in bankruptcy with respect to collective bargaining agreements?
Yeah, I mean, there's two overlays here. One is the Bankruptcy Code, and again, after a certain steel bankruptcy, where the steel company tried to get out completely from the union contract, the Congress adopted a series of protections for unions that's embodied in Section 1113 of the Bankruptcy Code. And essentially, the standard there is similar to the NRLB standard that you'd have outside of court, which is, if you want modifications to your employment agreement, collective bargaining agreement, you have to negotiate in good faith with the union, and you have to show that the changes generally are necessary for you to reorganize. It can't be just, I'd like to save some money on my labor. There really needs to be, I can't survive if I can't get these concessions, versus, I'd be a little more profitable if I could pay my employees less. And generally, the union is appointed as the negotiating party. Employers that really do want to change their union agreement often start the negotiations even pre-petition. We saw this in some of the big airline bankruptcies, where those pilot and flight attendant agreements and related retirement benefits and the like were big dollars for the union. And ultimately, under 1113, if you negotiate to impasse and you meet the standards, you can reject the employment agreement, but it's a very high standard, and in all likelihood, the bankruptcy court will try to signal some guidance, but encourage you to negotiate a deal rather than scorched earth. I would also note that even if you are able to reject an employment agreement, the NRLB standards don't go away entirely. So if you are hiring back some of the formerly union employees, you may still have some labor law negotiations, even if you aren't bound by the existing terms of the union agreement.
And if a debtor does meet this high burden, they're able to prove the points that you need to under the code in order to reject or modify a collective bargaining agreement, would the union have a claim for damages based on the previous agreement? And if so, is that claim entitled to priority? James,
Prior to enactment of 1113 of the Bankruptcy Code, the answer may have been yes, because Section 365 of the Bankruptcy Code controlled rejection of the collective bargaining agreement. But 1113 makes clear that, or at least, the connotation of 1113 makes clear that it's an exception to 365, and therefore there really is no ability to file a damages claim. And on the slide here, 38, there's some cases that have gone through the analysis and come out fairly definitively that there is no rejection damages claim for rejection of a collective bargaining agreement.
On the flip side, then you've got obviously a contract rejection would give the union a legal right to strike if it's governed under the National Labor Relations Act. So, assuming the debtor doesn't want to have a strike on its hand in addition to dealing with a bankruptcy, you do go through those, different steps before you would get to the point of rejecting a collective bargaining agreement. And those steps will largely be familiar to the employer in the debtor circumstance. The making proposals to the union to modify the collective bargaining agreement, going through mediation, all of those steps are pretty similar to the steps that would be done in the ordinary course without a bankruptcy filing. So you'd have mediators if you need it. At the state or the federal level, and make 3 proposals back and forth, all of the typical steps for negotiating collective bargaining agreements. So those are the ways that you would try to avoid some of these more drastic outcomes if the collective bargaining agreement is at issue in the bankruptcy.
So Heather, I'll stay with you. Collective bargaining agreements, the general term for most of them, about 3 years. What happens if one expires during the course of a bankruptcy case?
Right. If there's an expiration of the collective bargaining agreement, Section 1113 that James talked about may still apply to the agreement. So you've got a division in the lower courts on this issue, and some are considering it to approving a rejection and then treating it as expired post-petition. And slide 39 has some of the interesting cases on that. If you've got an expiring collective bargaining agreement during the pendency of the bankruptcy, and that actually can happen fairly commonly. Bankruptcies sometimes can go on for, a year, 2 years or longer. I'm sure all 3 of you have examples of bankruptcies that have gone on for far longer than that as well. And so collective bargaining agreements are typically 2 to 3 years. I think I've seen a couple of 3 or 4 year ones, but they're usually, somewhat shorter in duration. And so you really do want to be sure that you're addressing the collective bargaining agreements during the pendency of the bankruptcy, even if you don't have issues with the current collective bargaining agreement, you may still need to be negotiating for the next bargaining agreement. And as most employers know, outside of the bankruptcy context, you're almost always negotiating something with the unions for collective bargaining. So you really would be just continuing that process. And I'll let James or Robert chime in if they've had the CBA that's been expiring during the bankruptcy and how they may have handled that.
Yeah, I think the
I
courts are
go
still
ahead.
going to apply 1113 regardless of whether or not it's in effect or it's expired.
Yeah, and there is still, I mean, labor law still applies, even in bankruptcy, and that's true of generally laws. So, there's still probably a duty to recognize the union and talk to the union, even if you have no current CBA in place. You can't generally just say, "Oh, I'm a non-union shop," and all the formerly union employees are now, completely non-union.
And even in the current administration, the National Labor Relations Act and the National Labor Relations Board are going to make sure that labor laws are being followed even in the pendency of a bankruptcy. Obviously, the change in administration has changed the makeup of the National Labor Relations Board and the General Counsel at the head, but following basic labor law is still going to be expected and required.
We will switch our alphabet soup for a little bit and go from CBAs to NRLB to PBGC and retiree benefits, which looks a lot like some of the collective bargaining rules under the Bankruptcy Code. So, James, can you tell us about how a Chapter 11 might modify or terminate its retiree benefits in a bankruptcy case?
Right. So 1114 of the Bankruptcy Code is very similar to 1113. Instead of governing collective bargaining agreements with unions, it covers retiree benefits, which could cover, a union employee as well as non-union employees. So typically speaking, the negotiation that would take place with the union employees would be governed by the representative of the retirees would be the union. And for non-union employees, it would typically be a retiree committee. So the U.S. Trustee's office would probably solicit interest from the retirees to see if the parties wanted to be appointed to the committee to represent the interests of the non-union retirees. Like I said, very similar to 1113 requires good faith negotiations. The court is typically not going to allow the retiree benefits to be terminated or modified unless the judge deems it necessary to the reorganization and that the terms are fair and equitable to all parties, and that there's a balancing of the equities done. It was an interesting case back in 2010, the Vistion case, Third Circuit ruled that even if the retiree benefit plan said that it could be terminated or modified at any time by the company, 1114 still applies. In the Vistion case, the debtor in that case tried to argue that it didn't need to comply with 1114 because the terms of the plan itself said that it could be terminated or modified at any time outside of bankruptcy. And the Third Circuit said, well, we're not outside of bankruptcy, we're in bankruptcy, and you have to comply with 1114 no matter what. And the other aspect of 1114 that's important to keep in mind is that sometimes a company might try to avoid application of 1114 because of the Vistion decision by terminating or modifying the plan prior to the bankruptcy. And so 1114 provides that the court can go back 6 months prior to the bankruptcy. You can't modify or terminate your retirement plan within the 6-month period prior to the bankruptcy filing. And if you do, the court still has jurisdiction to undo that. And you still have to go through the process. And that process can be enforced even after the plan has been confirmed. So, you can't right after the bankruptcy is confirmed and the entity is reorganized, you can't say, okay, now we're out of bankruptcy and we're going to, terminate the plan or modify it. So the court still has some jurisdiction to be able to enforce that even after the company has emerged from bankruptcy. So there's some tools in bankruptcy that are actually a little bit more beneficial than perhaps maybe even outside of bankruptcy in that regard.
And Robert, real quick, if a retiree's benefits are modified or terminated in bankruptcy, can they make a claim for damages?
Yes, I mean, generally they can. 1114 contemplates that. They generally can make a claim, whether it's priority or not. Some of these people may have been retired for a long, long time, so it may not necessarily be priority and may get paid cents on the dollar along with everyone else. But yes, they can assert a claim. One other thing I just wanted to kind of note based on experience is these retiree medical benefits can be huge. I mean, some of these medical plans are very, gold plated. And, if you're covering retirees for 20 or 30 years of gold plated healthcare, I mean, this is a very expensive item. So these issues are really focused on in some of the bigger bankruptcies because it really makes a difference as to the rest of the creditor's outcome.
Do you want to switch topics? I think we're doing okay on time. We may get to everything. We'll see. We're going to switch to something I feel like it's gained more and more traction in bankruptcy cases these days and has become a real almost nuisance for people to deal with, and that is the WARN Act. So Heather, why don't you start us off and just tell us generally what is the WARN Act and what was it intended to do?
You bet. Yeah. And giving us yet another acronym here, but the WARN Act is a Worker Adjustment and Retraining Notification Act. It's actually quite a relatively old law. It's from the 1980s. It was originally intended to, when we still had a large manufacturing plants and plant closings, it was intended to give workers and their families and the general communities, so unemployment offices and worker retraining programs and skills retraining, to give everybody 60 days notice in advance prior to either a plant closure or a mass layoff event. And so it only applies to, it applies to all workers, but it only applies to, at the federal level, to employers with 100 or more employees, give or take, excluding some that are short-term or part-time. And then it does include all employers. So public entities, nonprofit entities, private entities, covers everybody in that regard, but only if you've got 100 or more employees and with workers working an average of 20 hours a week or more. The WARN Act, the only exclusion there is federal, state, or local governments that are providing public services. Generally, we don't see those engaged in mass closures anyway, so it hasn't been too much of an issue. But the WARN Act really is an advance notice requirement. There's a handful of technical words and phrases you need to use in the advance notice, but it's generally a very simple notice, half a page, and it's given to employees that are affected by either the mass layoff or the plant closure. And it can also be triggered by a sale of a business that results in a plant closure or a mass layoff event. So if you're in the process of a bankruptcy, then what you may have is an event in the bankruptcy process that triggers a requirement for giving WARN notices as well. And then there are penalties because it's advance notice. It has nothing to do with employee wages. It has nothing to do with benefits. It's literally just advance notice of a mass layoff or a plant closure. But there are penalties in the statute for failing to provide the WARN notice. And so you do have to be careful if you're going into a liquidation type bankruptcy, that event might trigger a WARN notice. If you're, there's some recent case law, interesting case law on that. So the WARN notice is just once you know that you're looking at a mass layoff or a plant closure, you also need to be thinking about the giving WARN notices 60 days in advance and the federal level. And then at the state level, there are some defenses to that listed on page 48 in the slides.
Let me go a little bit out of order.
Go ahead. Yeah.
From what I intended. So Robert, why don't you touch base on this a concept of damages or penalties for the warrant violations. And, so now a debtor's in bankruptcy, they may have violated the Warrant Act. What damages, what claims might they face? Are those claims entitled to priority?
Well, part of it will depend on if the Warrant Act notice was given before the case was filed. Generally, the debtor will take the position that's a pre-petition claim, gets paid cents on the dollar, might not necessarily even be within the 15,150 priority that we discussed. If it occurs post-petition, then there'll be an argument on, is it a post-petition admin claim or still an unsecured claim? And there's a whole bar of plaintiffs' attorneys that look for notices of mass layoffs and represent even non-unionized employees. And there is an ability in bankruptcy to assert class proofs of claim. So these plaintiffs' lawyers are generally pretty aggressive on trying to recruit a sample plaintiff or two, but then file for everyone, not just the one or two people, and try to get a class claim for 60 days of pay.
Yeah, it's very interesting. I recently was involved in a bankruptcy case where immediately class action plaintiffs came along. At the end of the day, all they really procured for their class plaintiffs was the statutory provision of pre-petition wages, 15,150. Nothing else was assessed on top of that. James, Heather started to touch on this, but there are defenses to the Warrant Act. What are some of those defenses?
So the ones that typically pop up in bankruptcy or for a distressed debtor is, first and foremost, you can argue that you're not an employer, but a liquidating fiduciary. So what you'd have to show there is that you were not, at the time that you terminated the employees, that you were no longer doing business. You were just in the process of liquidating the assets for the benefit of creditors, for example. Second one would be that it was an unforeseeable business circumstance. Like ones that you can imagine might come up would be like, I remember I had a client that had Russian investors, and when Russia invaded Ukraine, their entire funding sources dried up because of no one wanted to do business with Russian entities, even if you were not subject to the sanctions. There's also a faltering company exception, and that typically pops up when you're actively trying to either obtain financing or to obtain future business that will save the company. So, and which sort of prevented you from providing the notice, because if you had provided the notice to the employees, then it would hamper your ability to get the financing or to get the business, because you had to keep it sort of under wraps. And you have to show that it would have been sufficient to avoid the shutdown and they had a realistic opportunity to obtain the financing or the business. There's also something called a natural disaster exception. That's, if there was like an earthquake or something like that is completely unexpected. And then there's also something called a good faith defense, where you're not arguing that it wasn't required, but for whatever reason, you just kind of screwed it up, right? So maybe you provided a defective notice. Maybe one of the things that Heather was talking about that had to be included in your notice, you left it out or whatever. And you're basically asking the court to, reduce the amount of damages, either by limiting the, maybe you provided the best notice you could under the circumstances, and that there were reasonable grounds for your failure or, your omission. So those are the ones that you typically see in a bankruptcy.
Just to sort of put a cap on this, is an interesting recent decision by Judge Goldblatt out of the District of Delaware, where he says when you give less than 60 days notice and you're citing one of these exceptions as a reason for it, that you can't just list the exception. Sort of like a complaint can't list the claim or the recitation of the elements. It has to give some little explanation as to why you fit within a particular category. We are almost out of time. So Heather started to talk about this. There are some states that have their own mini Warrant Act requirements. Heather, do you want to just maybe shout out the few states that if I'm a debtor, I should be really concerned because they have some peculiarities.
Yeah, absolutely. So, in addition to the federal WARN Act, there are many WARN Acts at the state level. The big differences there are California, Illinois, and New York. Most states have some version of a WARN Act, but it mirrors the federal language and requirements. But California, for example, the required notice applies for 50 or mass layoffs of 50 or more employees, regardless the percentage of the workforce. New York requires a 90-day notice, so you really have to start thinking ahead as far as New York. And then Illinois applies to employers who have at least 75 or more full-time employees, so lower threshold there. So just be sure that when you're thinking about WARN Act notices, you're looking at both the federal as well as the applicable state or states, if you're in multiple states, that you need to comply with all of those.
Well, it's noon my time, but it's been an hour in this seminar so far. We were just slightly overly optimistic, and there was only one slide that we really didn't get to, and we were going to discuss non-qualified plans. But suffice to say that there are benefit plans out there where the benefits that are held in trust for employees may be reachable by creditors. Slide 52 references some of those. So if you're interested in that topic, look at slide 52 and go down that rabbit hole as well. But I want to, first of all, thank our panelists today for their time and for their sharing of knowledge on this topic. Thank you to Financial Poise for putting this seminar on. But that is all the time we have for today. I don't know if there are any questions that are out there, but if there are, maybe we have another minute. But thank you very much for attending today.
Thank you.
Thank you.
Thanks, everyone.